And here, my singular case all along is, my lord, the mortgage deed is dated, my lord, 10th of June 2019, and the sale deed is 31st of January 2022. So, my lord, the buyer did not exercise the principle of caveat emptor. The seller, my lord, that is the private respondent number 2, probably suppressed the entire thing. So I am left with a situation where RERA says you return the flat and the receiver is not to take possession. I preferred an appeal before the appellate authority. Appellate authority, my lord, sounded the same opinion. Now, from that, my lord, under the statute, I have the right of preferring a second appeal, which I have filed, that is pending. Now, in this backdrop, when everything came before RERA, my lord, RERA passed the impugned order. Kindly come to the impugned order, which is on page 206. Yes. Sorry, my lord, kindly grants me a moment. It's in volume 4, my lord. 206 in volume 4.
Yes, got it.
Chartered accountant so-and-so, being authorized representative of the complainant, is present in the physical hearing today and signed the attendance sheet. Advocate so-and-so is present in the physical hearing today, heard both the parties in detail. This authority directed the respondent, Yes Bank Limited, in its order dated so-and-so, in direction E of the order, the following. The respondent bank was also directed to take all necessary steps to vacate the physical possession of the flat, being flat number so-and-so, of the subject matter project, and deliver it to the complainant within 7 days from the date of receipt of this order of the authority through email. The respondent, Yes Bank, till date did not comply with the said direction of his authority. Meanwhile, the respondent had filed an appeal bearing so-and-so before the Honorable West Bengal Real Estate Appellate Tribunal, challenging the said order. By an order dated so-and-so, the appellate authority has been pleased to dismiss the appeal and upheld the order dated so-and-so passed by this authority. In the last order dated 30th of September, this authority directed the respondent to submit its contentions regarding compliance of direction E of the order dated so-and-so on the next date of hearing, that is today, in respect of vacating the physical possession of the subject matter flat. At the time of hearing today, the advocate of the respondent submitted that A, Ideal Estates Private Limited is required to be included as a respondent for adjudication of this matter, and Honorable WBREAT has been pleased to give that direction in the order dated so-and-so at the time of dismissal of the appeal. They are preparing for filing an appeal before the Honorable High Court at Calcutta against the order dated so-and-so. At the time of hearing today, the authorized representative of the complainant stated in reply, the physical possession of the flat has been taken by respondent. The ideal estate can be added as another respondent as per the direction of the...
So, Mr. Bose, I'm sorry to interrupt. There is a provision for appeal before this court itself from the appellate authority.
Yes.
This is the second appeal.
That is a second appeal. That appeal is pending. That appeal is pending.
So, can't this order also be impugned there if the appellate authority, I mean, this court
this
stays?
This order goes to the root of the matter, if I may say so with respect. First of all, let me tell your lordship, my lord, neither party has taken any steps pursuant to the appeal in the sense the status quo continues. I was directed to pay a fine of 5 lakhs and odd, for which I've taken out a stay application in the second appeal. That is also pending. And my lord, so far as the possession is concerned, neither party has done any steps. The appeal is pending. But today, if my lord...
Just a minute. Then, Mr. Bose, in the appeal itself, you can get an order of stay.
But my lord,
because you know better, there are judgments which say that if this court itself can be approached in a different jurisdiction, then in that case, writ petition will not be maintainable. I will not be entertainable.
My lord, the question is, if it is an order which is entirely without jurisdiction, if my lord sees RERA, my lord, the act, there are certain sections...
RERA ache amader? RERA Act. RERA. Act. RERA Act.
There are copy আছে ওইটা কোথায়
নিয়ে নেবেন
My lord, I'm sorry, my lord, my junior is not here.
এবার আনিয়ে নেবে এই সপ্তাহের জন্য
And I hope Mr. Bose I hope Mr. Bose is making submissions, but your lordship will kindly hear me on maintainability also.
yes yes I hear it.
Yes.
Yes, Mr.
I'm
Bose.
aware of it. Any aggrieved person, my
Mr.
lord,
Bose,
section
which
31.
section? 31. 31.
Any aggrieved person may file a complaint with the authority or the adjudicating officer, as the case may be, for any violation or contravention of the provisions of this act or the rules and regulations made thereunder against any promoter, allottee, or real estate agent, as the case may be. Bank is not involved here. Promoter, allottee, or the real estate agent. I'm none of the following. I'm not placing the rest of this thing. Kindly come to section 35. Where the authority considers it expedient to do so on a complaint or suo motu relating to this act or the rules or regulations made thereunder, it may, by order in writing and recording reasons therefore, call upon any promoter or allottee or real estate agent, as the case may be at any time, to furnish in writing such information or explanation relating to its affairs as the authority may require, and appoint one or more persons to make an inquiry or relation. So basically, my lord, it is restricted to promoter, allottee, or real estate agent. There are more, my lords. Section 38. The authority shall have powers to impose penalty or interest in regard to any contravention of obligations cast upon the promoters, the allottees, and the real estate agents under this act or the rules and the regulations made thereunder. So, my lord, how does the petitioner, in its capacity as the financier, my lord, fit into these categories, which is the general tenor of the act?
How is
No,
the
I
promoter
tell your
defined?
lordship, I do not hide
How is
one
the
thing.
promoter defined, Mr. Bose?
Promoter, kindly grants me a moment. Promoter is ZK. My lord has found ZK. Promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments, or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other persons and includes as assignees, or a person who develops land into a project, whether or not the person also constructs structures on any of the plots for the purpose of selling to other persons all or some of the plots in the said project.
I've seen it. Prima facie, it doesn't include banks.
It doesn't. Now, my lord, I tell your lordship, I showed your lordship the order against which the writ was preferred. Now, there were two prior orders passed by the regulatory authority, my lord, also the appellate authority, in relation to the same premises. There, the authorities concerned relied upon two judgments, one of Rajasthan High Court and the other, my lord, of the Supreme Court, where the Rajasthan High Court judgment was upheld. Now,
you have a
yes.
copy of this?
Well, may I just show your lordship that judgment, how they seek to bring in RERA into the scheme of affairs. But the point which I'm trying to make is, when my deed of mortgage is prior to the deed of sale, and the deed of mortgage contains such explicit statements and factors which play a very, after all, he cannot get a title or an interest which is higher than mine. I am the person named, my lord, in the registered deed of mortgage. So on what basis can the facts of these two subsequent cases be applied and said that RERA will come into the picture? Because SARFACI on those cases came into the picture after, my lord, the flats were sold. Whereas mine, my lord, my deed of mortgage is of 2019 and the deed of sale is of 2022. Well, may I just show your lordship the relevant portion of the, kindly come to page 191.
Yes.
The West Bengal Real Estate Regulatory Authority had passed an interim order. Paragraph 1, my lord, is page 191.
Yes, yes. Against that, it's 24th of June, 2024.
Yes, 24th
The
No.
order impugned.
Yes.
The
Now, my lord, will
The
come to
appellate
page
authority's order is-
192. 192. I just show your lordship relevant lines only. I won't read the entire order. Towards the bottom. Whilst the respondent number one, that is Mega
Yes, yes.
Resources Limited, entered into the agreement, there was nothing in the records of the learned regulatory authority that any mortgage had been created. The respondent number one thereafter got vacant possession of flat number so and so, and since then it is in occupation of the flat. The respondent number one paid the entire consideration amount to the respondent number two, and in turn the respondent number two executed and registered a deed of conveyance and so in respect of the flat in favor of the respondent number one. After it got possession of the flat, the respondent number one let out the flat to the company. My lord, kindly turn the page and come to page 195.
Yes.
After what the regulatory authority at the state level had said, a reading of the impugned order passed by the learned regulatory authority shows that the learned regulatory authority, placing reliance on a decision dated 24th December 2021, passed by the Honorable High Court of Judicature for Rajasthan in the case of Union Bank of India versus Rajasthan Real Estate Regulatory Authority and others, and the definition of promoter under section 2ZK, has observed that by virtue of a deed of mortgage executed between the promoter Ideal Real Estates Private Limited and Yes Bank Limited, the bank became a promoter as an assignee of all the obligations of a promoter were cast upon the bank. But that is after the sale deed was executed. The learned regulatory authority, by referring to the order dated 14 June passed by the Honorable Apex Court in petition for special leave to appeal, etc., has observed that in the event of conflict between RERA and SARFAESI Act, the provisions contained in RERA would prevail, and the RERA authority has the jurisdiction to entertain a complaint by an aggrieved person against the bank, as a secured creditor of the bank takes recourse to any of the provisions contained in section 13.4 of RERA. In the light of such legal proposition and considering the documents on record, the learned regulatory authority was satisfied that the respondent number one complainant was able to establish a prima facie case to get an interim order, and accordingly it passed the interim order as accepted above in exercise of power under section 36. So, my lord, this is the only way by which, my lord, RERA authorities assume jurisdiction. But, my lord, the point which I dare say, perhaps, and I say this with the deepest respect, which has to be considered by your lordship, can this blanket rule be applied in the backdrop of the sections which I have shown to your lordship, and particularly in view of the fact that there is a basic point of difference, namely, the registered deed of mortgage is 10th of June 2019, and the alleged sale deed is 31st of January 2022. Now, if my lord so desires, I can show your lordship at this stage, my lord, the relevant clauses of the mortgage deed, but my learned friend, I'm sure, will not really oppose that or raise any objections with regard to that. It is clearly stated, my lord, there is a list of flats which are unsold, which remain mortgaged. His flat, which is the subject matter of this instant application, comes within that list. He could not have sold it without the permission of the bank. The money should have been routed through the bank. No objection certificate should have been taken. Above all, my lord, there is a blanket order by which he's restrained from selling the mortgage property, which he's done, and I have not got any of the property. Now, my lord, if I have to restart the SARFAESI proceedings all over again by reason of an order passed by the RERA authorities, which are basically beyond and without jurisdiction, I dare say, my lord, the entire exercise of setting up RERA or the entire exercise, my lord, which I have undertaken. And kindly remember the fact also, I am dealing with a client to whom I have given 600 crores. It has been declared to be an NPA. Nothing is flowing into my coffers. And on the contrary, in violation and gross dereliction of the terms of the registered mortgage deed, my lord, they are merely selling away flats which are prohibited to be sold, and my lord enjoying the money. In this view of the matter, I humbly and respectfully submit, if my lord so desires, I can show your lordship the
No,
judgment.
I'd like to see the judgment of the Supreme Court, where Supreme Court has said
Very
that we'll
well,
have
very
primacy
well.
over that.
Very
এই
well.
পাখাটা একটু বন্ধ করে দেবেন?
Supreme Court judgment দাও। Copy টা।
May I utter one sentence?
Yes.
If your lordship permits. Because I will take a point which he has to first show how your lordship would enter this domain. Well, may I just show two things? I will not take any further. 1 minute. The prayers are challenging the order of 4th October. 4th October is not the decision where they have been found to be a promoter. That is not before your lordship. From that, they have prepared an appeal. Now I hear that he's saying that second appeal is also pending before this court. Your lordship is only looking at an executing order. First, your lordship, following the principle of CPC, if your lordship is an extension of the executing order, if your lordship takes it as a writ, then your lordship cannot go behind the decree. So these judgments may be academic, my lord, because his only prayer is on 4th October, which says that that order has become final, therefore I'm executed. This is the provision, my lord. Just kindly looks into this, because this might become academic.
My lord, with the deepest of respect, in case my learned friend is finished, I would say this is not academic, for the simple reason this goes into the very root of the matter. My lord, the writ petition has been preferred against the order which my learned friend correctly says is the order which has to be considered by your lordship. But that order...
Mr. Ray has raised a pertinent point. He says that you have already, as you also said, that you have already preferred a second appeal where the main order is under challenge.
Yes.
Now, if the main order goes, then the executing order or executing
But
court's
my
order
lord,
will definitely go.
then this order, my lord, subject to the second appeal being heard, then this order should be remain stayed for the time being.
That also you can take up before the second appeal itself, because the
My
second
lord,
appeal you can file
why
application.
not? I ask this question to myself: do I not have an independent right to challenge a subsequent order passed by the RERA
Could have,
authorities?
but once you have already presented a second appeal and rightly so in terms of the statute, then in that case, as the first question which I put to you when you opened the case, that if this court itself has power to deal with it in a different jurisdiction, why should the writ court? There is a direct judgment on this point also. I think Thansing
My lord,
Natmal is the first of such authority.
My lord, we had also brought a judgment, 2024, volume 6, Supreme Court cases 579. My lord, just grants me a moment. আমার কাছে কপি ছিল। এটাই তো। Sure. 2024, volume 6, Supreme Court cases 579.
Yes.
I will not trouble your lordship with the entire. Straight away come to paragraph 37.
Yes.
It could thus clearly be seen. My lord has found paragraph 37.
Yes.
It could thus clearly be seen that the court has carved out certain exceptions when a petition under Article 226 of the Constitution could be entertained in spite of availability of an alternative remedy. Some of them are thus. I come under 1, where the statutory authority has not acted in accordance with the provisions of the enactment in question. Here is RERA, my lord, not acting in terms of the provisions of the Act by passing orders against the bank, which should not be as submitted by referring to sections 31, 35, 36 and the definition.
No, but that has been interpreted. See, you want to make a factual distinction between this case and the case which was ultimately decided by the Honorable Supreme Court. Now, the Honorable Supreme Court, I have not seen the judgment, but according
we have
to
the
you
judgment.
also, it says that this RERA will have primacy over.
But in what background? In what background?
This, if it is only a question of background, then in that case, the question of jurisdiction takes the second seat, because jurisdiction it has.
With respect, no. My lord, perhaps this is just a suggestion for my learned friend. The entire, my lord, this impugned order was passed sometime, my lord, on the 4th of October 2024. The parties, my lord, have maintained status quo. Nothing has happened. If my learned friend wants to argue the point of maintainability and what has just fallen from my lord, Let this order be kept in abeyance. We shall go for some
But
time.
then
at least.
I'll have to entertain the writ petition then. I am at the question of entertainability only.
Well,
because,
I am
see, there are
inviting.
two things, Mr. Bose, against you. One is that there is a statutory remedy before this court itself. This court itself in a different jurisdiction has the authority to deal with it. Now, in such a case, whether it should be entertained. Second is you have already availed of that remedy. You have filed a second appeal which is pending. Now, in the teeth of that, if the writ court intervenes, I don't think it will be.
I ask myself, well, can it not be decided where the statutory authority has not acted in accordance with the provisions of the enactment?
But this can be decided by the second appellate
Well,
court
but
also.
the point, it can be, but that doesn't rule out your lordship's jurisdiction.
It does in a sense, Mr. Bose. It does. For example, if there is a second appeal in under section 100 filed before this court, and then I come up in a writ petition saying the civil court did not have jurisdiction.
No, my lord, I am going a step further. I am saying, my lord, when my deed of mortgage is much, much prior to the sale deed, and there are express provisions in the deed of mortgage which prohibit them from taking the steps which they did, to which, my lord, RERA, the promoter, as also the home buyer, they are all parties. I do not know whether they are acting conjointly with each other. I will not go so far as to make any such allegation.
All this can be taken into consideration by the second appellate court also, Mr. Bose.
My lord, today, my lord, kindly consider once the judgment of the Supreme Court thereafter, whether, my lord, it is justified in coming to a conclusion at this stage that just because the second appeal is pending, my lord, your lordship lacks the jurisdiction to entertain this.
I won't say lack the jurisdiction. I'll say I will not entertain it. The difference between maintainability and entertainability.
Yes, but the point
is maintainable.
The order
It may not be
remains.
entertained.
My lord, unless the parties say that neither will act in terms of the order, there is this Damocles sword which is hanging on my head. Give physical
Mr. Bose,
possession.
have your remedy before the second appellate court. You can file an application today itself and get the order which you want the writ court to
But the
pass.
question is, for how long, my lord, will... I do not want, my lord, to be clamped
Mr. Bose,
with...
all these days, because this writ petition was filed when?
Oh, long
It
ago.
was filed 7th of October 2024. So in the meantime also you could have filed it. You can file it.
We have not filed it because this was pending.
Yeah, I
very
understand.
frank.
But Mr. Bose,
Because,
you can still file it because the remedy is there. The order is live.
my lord, let me just show your lordship the Supreme Court order.
Please.
Supreme Court judgment factual judgment of acknowledgement of Rajasthan
আমাকে দেখাও। কপিটা দাও।
page number 36.
Well, I just show your lordship first the Rajasthan High Court order because Supreme Court from where it went up to the Supreme Court. This is there's a copy the other. You know. Anirban.
Page 36 of
My lord, kindly come to page 36 of 60.
according to the lawyers, this was done with existing charges.
Just a minute.
According to the lawyers.
Well, the second paragraph, last 4 lines. According to the allottees, this was done without verification of existing charge on the properties in question. If you haven't done it, it's not my fault. The allottees therefore alleged before RERA that such loan was sanctioned wholly fraudulently and with malafide intentions. The loan was, in this case, my lord, given much earlier. It appears, my lord, kindly let me place the first few lines of the second paragraph. It appears the allottees had taken loan from ICICI Bank against the allotment of flats in the strength of tripartite agreement. Resultantly, the security interest in favor of ICICI Bank was created. The same was also registered with the Central Registry of Securitization, Asset Reconstruction and Security Interest of India. Despite this, according to the allottees, developers had taken the loan of 15 crores from Andhra Bank, which is now merged into Union Bank of India, the present petition, by creating a mortgage in favor of the bank. So the loan was subsequent. In our case, the loan was in prior in 19. And this project was financed by us. The terms of the deed are very clear. Well, may I just kindly see
page number 50 of 50.
Page number
50.
50.
As per the provision.
My lord has got page 50,
Yes.
about 7-8 lines from the top. As per the provision, the promoter is precluded from mortgaging or creating any charge or apartment, plot or building with respect in which he has executed an agreement for sale. Same here. If he breaches this obligation, such mortgage or charge created shall have no effect on the right and interest of the allottee. This provision thus creates a new obligation and corresponding right in favor of the allottee. Such provisions cannot have retrospective effect, etc.
Clearly held also that if it is created subsequent. If the
So, my
mortgage
lord, the
is
mortgage was created subsequently.
in the facts of this particular.
So, the manner and circumstances under which the courts hold that RERA will prevail in case the Surface Act has already intervened and the steps taken in terms thereof is totally different from our case. Our deed of mortgage is much earlier and the sale deed. I would go so far as to say it's a case of fraud. No due diligence test was perhaps done by the home allottee. The borrower, my lord, did not make known the fact about the existence of this mortgage deed which was executed in 2019.
10th of June 2019 is the date of the mortgage.
My lord, now in this backdrop, I'm showing you the facts particularly because to show that these two judgments on the basis whereof they draw inspiration that the RERA will prevail has no application at all. Now this went up to the Supreme Court.
Actual settlement was.
Kindly see, my lord. (2022) Life Law Supreme Court, Union of India.
It only says in paragraph 36 of the Rajasthan High Court is upheld.
We are in second paragraph. We are in complete agreement with the view taken by the High Court, by which the High Court is ultimately concluded in paragraph 36 is under. Our conclusions can thus be summarized. Regulation 9, etc. is not ultra vires. The delegation of powers in the single member of RERA to decide complaints filed under the Act.
4 and 5.
4 and 5. RERA would not apply in relation to the transaction between the borrower and the banks and financial institutions in cases where security interest has been created by mortgaging the property prior to the introduction of the Act, unless and until it is found that the creation of such mortgage or such transaction is fraudulent or collusive. There is no such. It is not so over here. It will not apply. RERA authority has the jurisdiction to entertain a complaint by an aggrieved person against the bank as a secured creditor if the bank takes recourse to any of the provisions contained in section 13(4) of the Act. I didn't go to RERA.
Interestingly, the private respondent, who is the Mumbai, he approached DRT under section 17.
And my lord, I should tell your lordship, I have already told your lordship this once, the home buyer initially approached DRT.
DRT under section 17.
Under section 17. Then retracted and then immediately came before RERA. Perhaps my lord found that he had better chances here, abandoned the proceedings and got the order and is merrily enjoying, my lord, both worlds. And I'm left out in the lurch, out of pocket by 600 crores, given, made necessary applications in accordance with law, got the necessary orders, and yet clamped, my lord, with a fine of.
Even if I'm with you, Mr. Bose, this hurdle is too big for me to cross. You have already preferred a second appeal. It is pending before this court. How would the writ court intervene? It would be improper for the writ court to intervene when the division bench is in season of the matter and there is an appeal pending where you can have the same remedy. It would have been one thing if you would have not preferred the second appeal at all.
Then I would be left out totally in the lurch.
Yes.
I would be totally left in the lurch.
Because then in that case,
but today, considering the fact that my lord has seen the impugned order, they were told, and in spite of that, my lord, the regular
you could have brought it to
authority.
the notice of the court.
We did.
The single bench,
Kindly
I mean, the second appeal, the second appellate court. could have been informed about this, that this is what they are
This
doing.
was a subsequent
and
event, my lord, and it
This
was
could have
a
brought in
fresh new order.
by way of an application, because I think that the subject to hearing, Mr. Rai, that the second appellate court is definitely having all the powers.
My lord, and then in that way, I understand what is passing through your lordship's mind. Your lordship is saying that any order passed by your lordship, my lord, would be admitting the appeal and interfering with the jurisdiction of the second appeal.
Yes.
If in some veiled way, my lord, if my lord could extract some sort of undertaking from them not to take any steps, I shall move the second appeal.
Difficult.
But I personally say, my lord, and I say this with respect and with all humility, your lordship has the jurisdiction. This is something.
I know I have the jurisdiction. I not for once I'm saying that I do not have the jurisdiction, but whether I should exercise discretion in exercising the jurisdiction in the affirmative, or I should not entertain the writ petition is
My
the
lord,
question.
I asked this question to myself: why should discretion not be involved?
Because of you having approached the second appellate court number 1, there being a second appellate remedy before this court itself in a different jurisdiction, I cannot because then this is going to be chaotic. Then litigant will not know as to which court is to which court is to be approached, and there will be absolute anarchy, because there is a second appellate court having jurisdiction over the same matter over which I am exercising jurisdiction under Article 226, knowing that there is a second appeal pending. I think it will be far too much.
My lord, may I put it this way? When the regulatory authority, my lord, passed the impugned order, it was made aware of the second appeal.
I agree to that.
I am showing to your lordship that RERA does not permit any order being passed against banks.
Then there was no stay, therefore they could have proceeded. You can get a stay still.
So therefore I'm saying it does not stop your lordship, my lord, for lack of a better word, from using your lordship's discretion.
Discretion is the fetter.
Yes. Use your
cannot
discretion.
exercise it like one can do arbitrarily. I'll be whimsical if I do that.
Reading the prayer will means we can
just, my lord, my learned junior requests me to point out the prayers in the writ. Interim stay be granted. My lord, it is on page 20 of volume 1.
That is only when I'm satisfied that I'll exercise discretion.
Yes, but kindly see, my lord, if it can be couched in any way commensurate with your lordship's discretion. An interim stay be granted directing the respondent state authorities from giving any effect to and further effect to the order dated October 4, 2024, which has been passed in complaint number so-and-so, till the writ application is disposed of, subject to the outcome of this writ petition till such time orders are passed by the Honorable Court in the second appeal intended to be filed by your petitioners. At that stage, it had not been filed.
It had not been filed. Now it is filed.
Now it is filed.
So even that way, it goes, because this prayer also shows that once you will file the second appeal, you will not be able to get this order, because it says intended to be filed.
But I respectfully submit, my lord, if your lordship feels that your lordship's jurisdiction is not taken away and discretion is coming in the way because the second appeal is pending, your lordship does have the jurisdiction and the power, my lord, to pass some sort of order which protects my client till such time I make an application in the second appeal. Because after all, kindly do not forget the fact, second appeal arises from a particular order. This is a subsequent order. I wouldn't be surprised if again, my lord, my learned friend goes and makes a submission over there that this is a separate order, there should be a separate appeal and things like that. So keeping that in mind, considering the fact that I've approached the writ court in respect of an independent order passed subsequently.
Appellate court will have all the powers to give you the remedy that you are entitled to. Writ court, I think, should keep its hands off.
But I was wondering if my lord could give us some protection till such time I file the application. That is all.
For so long, there has been nothing happening.
Nothing has happened.
Nothing has happened. So I don't think.
I leave it to my lord.
Yes, Mr.
But I appreciate what you spotted from Mr.
Rose.
Rose.
Mr. Rai, why
Forgotten my
is
name.
it difficult for him? Till the time he moves the second appellate court, why don't you maintain the status quo?
I'll point out why, my lord. But this is not only one of the instances, my lord. Not about Yes Bank. It's about what the RERA has to do. Now, my lord, two things your lordship will kindly keep in note. And I shouldn't be saying this, but I'm pressed to say this. My lord, in such situations, it is a case of complete forum shopping. Would your lordship require an authority to not take steps because my learned friend is now saying that no, this is not the correct court, I'll go there. And that is not under his contemplation also, my lord, because that is his interim prayer.
In the interim prayer, he hints that he'll be going to the.
So, Malad, that is something Malad kindly appreciates. The interim prayer is beyond the scope of the main prayer. There he says, I might go. He has not said when he has gone before the second appellate forum, Malad.
No, by the time he had filed the.
I understand. Malad, I am only on the
petition he had not.
I'm on other aspect, Malad. Definitely must have gone after October. He has not yet disclosed when he has gone. Now, my lord, why has he not approached that court by this time? So he's taking a chance here before your lordship. Would your lordship allow that? That is the question. It is not about this matter, my lord. It is about a general, my lord, application that whether your lordship will allow such a situation. I have never said alternate remedy throws out any person. No, it's a discussion we are talking at.
Yes.
My lord, I have made a submission that 4th October is something he cannot say is without jurisdiction now at this point of time. Because, my lord, he had availed the remedy of appeal before the appellate forum. Now he's again pursuing that before the second appellate forum. He comes in now saying that they did not have, these are questions of merits. Whether that mortgage is within or outside, whether it falls in the promoter or not, well, that becomes a question of merit.
It has a bearing, mortgage being within a particular time and something taking place thereafter has a bearing in view of the reasoning given by the Supreme Court also.
Supreme Court has said.
My problem is not there. My problem is he's having approached the second appellate court. If he has already approached the second appellate court, in that case, then
let him take steps there. He can't say here that, because then, my lord, it will be again jumping the gun again. Your lordship will be assuming the jurisdiction of the second appellate court, requiring me to concede, and then the second appellate court.
I'm not requiring anybody.
No, my lord, that's what he is intending, not your lordship. He is saying counts the order in such a fashion.
It's his duty to do that as much as it.
So that's why I'm also opposing, my lord.
No to it.
Because, my lord, it is assuming the jurisdiction of the second appellate court, which I don't think in the writ court ought to be doing. And it also does not fall, my lord, within the parameters where your lordships, in spite of there being an alternative remedy, takes up the matter. So that is my submission, because there are two other judgments. I don't want to go there. Bikram Chatterjee also says the same thing.
Bikram Chatterjee, I think, has been taken.
Yes, that is on the basis of the Rajasthan High Court judgment, my lord. That is quite extensive.
Doesn't apply in our respect.
So that becomes, now, if your lordship sees the subsequent judgment, at least to the extent that the mortgage was created beyond the RERA, that brings it within. After that, if you want to say it is not within that period, that becomes a question on merits itself. It is not that promoters do not include banks. That is what his submission were.
No, that though I think Rajasthan High Court.
Rajasthan has held, and that has been upheld by a speaking order. So it's a Supreme Court judgment now, merged. If it wasn't a speaking order, maybe, but it's a speaking order, so it's a merged decision.
Mr. Rai, you are appearing for whom?
I am for RERA, my lord.
RERA means?
My lord, restaurant number 3, I'm sorry, my lord. West Bengal Real Estate Regulatory Authority, my lord.
Very.
I am the so-called watchdog, my lord. Yes, my lord, I have to take care of whatever is.
I am respondent number 1.
You have to be respondent number 1.
Sir,
Yes,
I have just 2 issues if I indicate. Number 1 is, there is a, and your lordship has appreciated it, there is a complete framework under the RERA Act. So, my lord, firstly, an appellate tribunal comprised of a learned retired judge of the High Court and my lord, other judicial and technical members. Second appeal from that, my lord, order passed by the WB REACT to under section 58 to the High Court. So it's a complete procedure. You can't really bypass it. I do appreciate that at a time, my lord, when WB REACT appeals were not being regularly filed in the High Court, they filed the writ petition. But now, my lord, there is a judgment, or rather an...
It was filed at that time.
Yes, this is, I think, 6 months ago.
6 months ago.
6 months ago, and to be fair to my lord, the petitioner, at that time, my lord, we were not very, I personally was not very sure of what to do. In fact, thereafter, my lord, we had filed a second appeal before, my lord, the division bench presided over by Justice Tandon, and his lordship, my lord, delivered an order saying how it should be numbered. So, my lord, I'll give that to Mr. Bose.
I have it.
Yes. So, my lord,
So that is now functional.
that is now, the second appeal provision is fully functional.
Section 100 has been applied to it.
Yes, and my lord, after admission and question of interim relief, the second appeal, if it admitted, will be heard by my lord, the learned judge taking up second appeals. And the department has been directed by the judicial order how to number, my lord, these appeals. So I fully appreciate that at the time, my lord, when this writ petition was filed, it was, my lord, a grey area. I also fully appreciate it may not have been possible to mention the matter and have it listed or withdrawn. But now, my lord, that my learned friends they filed the second appeal, they're at liberty to move the second appeal tomorrow. My lord, there is nothing to prevent them. And my lord, the only thing is, if your lordship today, my lord, makes one observation, my lord, permitting them to have some form of a stay, they'll go and say that learned judge had given me a stay, please have it continued. And nothing happens in one day. You can mention it at 2 p.m., you can mention it at 10:30 tomorrow. There's no difficulty. So, my lord, I would humbly submit that they would perhaps, my lord, withdraw it and move tomorrow. My lord, we are not, at the time of consideration of interim relief, if second appeal is admitted, matter can, my lord, be decided. And, my lord, second point, most importantly, after, my lord, WB REACT's order, legislature, my lord, feels that interim relief is only possible if second appeal is admitted. So, my lord, it's an exclusion of judicial scrutiny.
That provision?
My lord, section 58 of, my lord, the RERA.
That's important.
My lord, may I draw your lordship's attention, firstly, my lord, to the first appellate provision, which is section 44. Application for settlement of disputes and appeals to the appellate tribunal.
Yes.
So, my lord, and composition of the appellate tribunal.
Yes,
is-
I've seen that.
Your lordship has seen that. Now, my lord, kindly see section 53, my lord, is powers, very wide powers, even examining witnesses. Then, my lord,
It's all about the tribunal.
yes, then 58. Section 58. Any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the High Court within a period of 60 days on any one or more of the grounds specified in section 100. So, my lord, legislature, my lord, in its wisdom has said that after REACT's consideration, it's only, my lord, limited scrutiny. That,
It's
my
a
lord,
substantial question of law.
yes, that can't be, my lord, expanded in a writ proceeding. Secondly, my lord, it's only if, my lord, a second appeal is admitted, does a question, my lord, of stay or, my lord, some interim protection come up. So, till my learned friends are able to show that there is a substantial question of law on which his second appeal will be admitted, he, my lord, can't have the benefit of an interim relief as per legislative intent. So, therefore, my lord, without going into these issues, if my learned friend takes it back and, my lord, mentions tomorrow before the second appeal court, I think all the problems would be resolved.
Yes, Mr. Bose.
My lord, I will not take it back. Those are my instructions. The rest I leave to your lordship. And secondly, my lord, kindly keep in mind the submission which I made in this regard. The second appeal is from a particular order passed by the regulatory of the appellate authority. Today, I have come up against a subsequent order. Does it therefore mean every time the RERA authorities, my lord, pass an order, every time I will be thrown into the pit of the second appeal saying second appeal is pending and therefore we cannot entertain?
Every time I have to file.
New directions are given, new things are told to me, and I will be told that till the second appeal is heard or till the second appeal is disposed of, or you move an application at the second appeal, you're not entitled to any order. Today, if I can show your lordship that the basis of my application is a jurisdictional error, that RERA doesn't have the authority or the power or the jurisdiction to pass any orders against the bank. When I am singularly and stressfully pointing out to your lordship that the deed of mortgage which I am relying on and which is not disputed is of the year 2019 and the deed of sale is 2022. When I'm telling your lordship that the 600 crores was the loan taken, they are an NPA. They are merrily selling away all the flats which are mentioned in the schedule to the deed of mortgage, which prohibits them from selling. Would it be justice meted out to me, asking me to go to the second appeal every time a new order is passed? I have come up against a new order.
Project that keeps on passing orders at the instance of the home.
And it's a project, it's an ongoing project. They will keep on adding,
Home buyers.
they will keep on adding flats and home buyers will flock to buy them. They will.
The order which you have challenged here is only one passed in execution as submitted by Mr. Rai. And I
It
find
is a
him to be,
it is a continuation.
but it's
but the
not
po-
by the appellate tribunal. It's by
No,
the
no, no, no.
it's
It's not
RERA.
by the appellate tribunal.
So therefore, it is executory in nature, executing order. Now, here, once you have preferred a second appeal, the second appellate court will definitely have all powers to state whatever execution or whatever injunction is supposed to be granted will be granted by the second appellate.
I have-
Kindly think of this, Mr. Bose. We are in a precarious situation today.
I am more
Today, if-
precarious than anybody else.
No, the court also. As a writ court, suppose I entertain the writ petition and the second appellate court finds that there is no substantial question of law involved in the appeal and it wishes to dismiss the appeal. What would happen? Or just think the other way around. I, by a speaking order, dismiss your writ petition and the second appellate court feels that yes, there is a substantial question of law involved. So that is why two courts having exercising different jurisdictions in on different sides should always avoid taking up the same matter.
My lord,
That is why
today,
I again
today,
say,
I
please,
dare
something
say,
Nakmal
my
wants.
lord, I think I am aware of what is passing through your lordship's mind in the line of judgments in this regard. But kindly also keep in mind the fact that today, if your lordship's conscience is disturbed by the conduct of the borrower, my lord, and your lordship feels that RERA is infiltrating into a territory and getting orders from and granting orders in favor of home buyers when it has no authority to do so, will it be
Mr.
improper
Bose,
on the part of your
I
lordship?
could have tried to get into that territory if the second appeal had not been filed. Once it is filed, it becomes all the more difficult for me
Well,
because
this way, what will happen is more flats will be sold, similar orders will be passed,
Let
and
us
every
see, let us
time,
see.
my lord, I will be told you go and already there is another application.
the second appellate court is in the season of the matter. We should not feel that it will not give justice. It will do whatever is
Well,
necessary.
considering the fact that this has been, all home buyers have been flocking. I started off my submissions by saying there is a bogey of bogus applications being made before ERA because they know if they approach DRT, they know if they try to take refuge behind the SURFACE Act, they will not get anywhere. So this is the best refuge.
Very
So
well.
kindly keep
Keeping
it in
for
mind.
orders tomorrow.
Yes.
Please be here.
Yes, yes.
Because I might like to hear some more.
Yes, yes.
Maybe
I'll
5
come
minutes,
here.
but it is essentially for
if
passing the orders.
Yes, if your lordship thinks like entertaining the matter, I'll take 5 minutes on merits.
A prima facie, I should disclose my mind. I'm not.
Yes.
But let us see. I'll go through the judgments and heard learned advocates appearing for the
My
party.
learned junior says, of course, this is just a request. If instead of tomorrow, it could be day after tomorrow. She's not in court
Yeah.
tomorrow.
Mr.
I will never have an objection.
Subject to convenience of the
Subject to your lordship's convenience, of course.
Very well. I wanted to finish it off.
bench. Then keep it.
Very well.
Then keep it.
No, if it's inconvenient for you, then
No, 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 no.
Coming tomorrow, that's all.
It's just that she's not coming tomorrow for
so very
personal
well. We'll
reasons.
have it day after tomorrow.
Yes.
Uh,
No difference.
heard learned advocate appearing for the respective parties. Let the matter appear for orders on Wednesday at the top.
Grateful, my lord.
Milord, I also, Milord, to be honest, felt how can this be done? When I saw it for the first time, then, Milord, it slowly sunk in that perhaps this is possible. So if your lordship does entertain, I'll take that 2 minutes to explain, my
Yes,
lord.
yes. I will also. That is why I'm taking this time. I'm not making. I'm not in haste to.
If your lordship takes
pass a
it back,
judgment now.
RERA,
But-
my lord, RERA is for the benefit of flat owners because they've been oppressed enough. Now, what this, my lord, form of jurisprudence says is that every promoter takes a construction loan. Now, the question is, promoter taken a construction loan, does the bank to whom, my lord, there is a mortgage created have primacy over rights of home buyers? Answer, my lord, given up to the Supreme Court is no.
No.
There's enough different factors.
That's the
That is the
way,
problem.
and the way out
The
is
factual
the
aspect
s-
is different.
the
I
sec-
keep on going back to 2019 and 2022. Prior mortgage, prior registered mortgage. That is a
So the
very
s-
crucial factor,
second
especially the deed, that certain
no
of the terms
difference,
and
my lord.
conditions.
Makes no difference
Anyway, my
in my
lord, we'll
humble
consider.
submission. Second mortgage is enforced, you will not come into RERA jurisdiction.
এটা ওদের বই বোধহয়। না আমার বই না।
বইটা দিয়ে দিন আমাদের একটা আনিয়ে নেবে
They are
লিখে নেন অ্যাফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট টু দিস সবাই তো অ্যাপিয়ার
My lord needs a book, my lord. I can give your lordship my book.
I'll have it from my library.
Excuse me. Grateful, man.
Thank you. এটা হলো বেঞ্চ
নটুটে নেবে? আচ্ছা তুমি যশ সাহেবকে বলো, তাহলে আমরা বসে রইলাম, এত আগে বলে দেবে।
তো আনিয়ে নিতে পারবেন হ্যাঁ হ্যাঁ ঠিক আছে
Item number 8.
8, my lord, I'm for the petition. I'm praying for not to my lord
I'm for the
only.
respondent number 3, Hindustan Petroleum.
My lord, Mr. Shoibal Acharya appearing for the petitioner is engaged in.
Since long you should have told him then
My lord, he is engaged in court number 25. My lord.
Very well, I'll come
Not
back,
to be
Lord, the
my
next day. But I put my learned friend to notice that I'll take a point about the maintainability.
it's not today tomorrow
tomorrow, my lord.
tomorrow
Grateful, my lord.
I'm great.
Number 9.
May it please, my lord.
Yes.
This is my writ petition, my lord, against my lord the Punjab National Bank in respect of my lord a property which is under my lord an extremely dilapidated condition, my lord. The bank, my lord, in this case, my lord, I'm led by Mr. Bhattacharya.
My lord, there is a case. Building has been declared, my lord, to be a dangerous building. I'm the owner of the building. KMC has already. Now, I have been writing to them. Item number 9 and 12. Item 9 is in respect of
9 and
banks.
12
Item 9 and 12, my lord, in respect of the same premises.
12টাও একটু দিয়ে দিন 12 12
12,
respondents serve in all
my lord, the respondent is different. 9 is bank and 12, my lord, is Eastern Railways. Both are tenants, my lord. 9 is in respect of the second and third floor. Sorry, first and second floor, and 12 is in respect of the ground floor. Now,
take your breath take your breath normalize your breathing and then let's have
I'm okay. It was from upstairs to downstairs, so it's still
Understand.
better. Yes. My prayer is very simple, my lord. I have this building needs to be, my lord, there has to be a lot of renovation work to be done, repair work to be done. There are electrical wirings which are 50 years old. The building is 100-year-old, declared to be a dangerous building. Now, I've been writing to them, at least for a temporary basis, shift to some other place, let us repair. Let us change all the wirings. Let us do it. No response. Only bank, there was one response from the bank asking for my title deeds, which I have provided. Apart from that, no response. I have annexed, my lord, the engineer's report and although the electrician's report.
and where is the declaration that it's a dangerous building
My lord, that is when the photographs, my lord, I'm carrying the photographs. In
no
fact,
is there a declaration by the municipality I
yes,
think
by the
executive engineer-
municipality. They have actually put up, my lord, the It said Bipodjonok, put up, my lord, boards on the building. Well, I'm carrying, my lord, the notice I've also intimated to them. Unfortunately, the notices as annexed, my lord, the notice by which I have communicated to them, my lord, this annexure is not there, my lord, but this is how the KMC has come up and put up a board.
But they issue a notice also, I think.
They issue a notice also, my lord. The notice, unfortunately, my lord, has not been annexed, but I have given them a letter on August 2024, informing them that I have received notices from KMC and fire department. My only request, either we do it because I'm the owner, the whole obligation comes to me, or, my lord, they do it. They do it at their own, because they're the ones they're occupying for more than 50 years. And one is a bank, another is Eastern Railways. Something happens, fire hazard, anything happens, entire thing will be on the owner.
Yes, bank ma'am, what?
My lords, I'm appearing for the respondent. My lords, I'm praying for the time to file reply for the same.
Reply, this is a very small matter. You kindly take instructions. Why are you not vacating it? If the building is dangerous, if some
lord,
mishap happens, what will happen?
I'm led by Mr. Shambhu Mahato. My lords, I have been instructed for this. I have to take instructions for the same.
Ask him to be here tomorrow.
Sure. Obliged, my lord.
And, my lord, item 12 is my learned friend is appearing, my lord, for the railways.
So far, I have gone through the brief, practically these are landlord-tenant dispute.
That I understand it's there.
97 Act, he has got all remedy before the civil court and union. By this procedure, he wants to evict me.
No, I'm not going. I don't want to evict you. Temporary. My prayer is temporary basis. Either you do it, or if they don't want to move temporary basis, let them take the responsibility at their own cost consequence. They're occupying the ground floor. Let them do it. I don't want to disturb their possession.
If the building is dangerous, something happens. I understand that a person cannot be evicted by way of a whip from the writ court. That I understand. Law is settled.
Rebuilding provision is there.
Yes, that is there. I am aware of that. I would have put this question of maintainability. That is why I wanted to see if there is a declaration from the municipality. Now, if there is a declaration from the municipality, if I'm called upon to decide the issue, I'll decide it on a question of law as to whether writ is entertainable or not. Authorities are legion on this point.
Yes.
That writ may not be entertained, but then looking at it from the safety point of view, if the building has been declared to be dangerous.
Sometimes in kind of genuine notice are pasted, sometimes in collusion notices are pasted.
So you kindly get instructions as to whether really the building is dangerous, or you say that it is not dangerous. Then in that case,
it's a 100-year-old building, my lord, it was SP Mukherjee Road, and the photographs with wirings all dangling. In fact, my learned friend's client would be benefited, my lord, if the repair work is done, if the wirings are changed. 50-year-old, my lord, no wirings have been changed for last 50 years.
Whether the atonement notice has been given or not subsequently.
Well, I've given them notices saying that I am the tenant. Now, they have also none of them have paid, my lord, any rent for the last 50 years. I'm not going into that. That's a right I have under the civil law. But this moment, my lord, I'm not concerned with eviction.
Petition is not maintainable. Is even I have seen judgments. I have suffered orders also on this count. But then I am on the point of the safety, because take instructions on that. I'm keeping it tomorrow.
No, tomorrow at least 7 days time.
7 days.
Try today, but even by today, I do not know whether.
Then Malad keeps it day after tomorrow, Malad. Let them.
Thursday.
I shall try my best. Keep it on Thursday.
Thursday. On the prayer of the learned advocates appearing for the respondent. Let the matter be listed on Thursday.
Some more orders, please. Submission, some
service is affected on all.
Yes, Malad. Service. Evidence service.
अच्छा आलादा आलादा order करबे ना.
This is item number 9.
9 আর একটা 12. 9 এ লিখতেন
কোনটা refuse আছে? Eastern Railway, my lord, it had come back as refused, but my learned friend is appearing. So
The railways also you are appearing. Railways you are appearing.
railways, my lord.
The respondents are represented বলে লিখে দেবেন. Respondent numbers 1, 2 and 3. দুটোতেই তো 12টা একবার দেখি.
Here, my lord,
আচ্ছা 12 নম্বরে 1 to 4. 12 নম্বরে 1 to 4. You are appearing for all 1 to 4. KMC is to be added as a party. Point of maintainability I have recorded also.
Let it be understood that they will come with some practical solution so that something can be worked out. Maintainability, I understand, but sometimes may I file my affidavit of service, my lord, be taken on. Grateful.
Number 10.
I beg to appear on behalf of the petitioner, my lord.
But I'm appearing for the respondents number 18 and 19 virtually. My lord, am I audible?
Petitioner's son has made one
My lord,
representation
am I audible, my lord?
respect of that land
Yeah, just a minute.
regarding the obstruction by the private respondents by constructing something on 9 July, as well as that is disturbing my ingress and egress. I would kindly come to the representation which is annexed in page number 121. It is made by my son, Ramakrishna Maiti, and kindly come to page 122, second paragraph, all that illegal construction over the land in Dag number 287 of 703, nature of land is Nayanjuli, means a water body and rest of the land adjacent to PWD road, Andhra Mouza Paschim, Sridharpur, jail number such and such, Andhra police station, Dolahat, Dokhin 24 Parganas. The above mentioned persons are doing the illegal construction over the land of water body in Dag number 287, 703 as well as PWD road. The said building constructions over the road are caused blocking front position of one shop of ours and hereby have allowed the government road to be encroached, thereby causing ingress and egress of the ours be adversely affected. Lord, this has to be considered and disposed of by the authority concerned.
Lord, I have a preliminary point, my lord. I beg to for the statement. Whether, my lord, this would come in this, because your lordship has been assigned matters from court number 14, where it's the unauthorized occupant act eviction, whether this comes under the State Highways Act or not, what I was asking myself. Perhaps this is an encroachment over the PWD and which
So it won't be under group 9.
it will be group 1.
That is what I'm saying. It will not be under
No.
group 9.
Lordship, this Nayanjuli, the adjacent, I have to address on this. If my learned senior friend raised this issue, Lordship, may remember that the state highways, the adjacent portion of the highways, even the Nayanjulis may be considered as highways under the 1964 Act, subject to correction, my lord. If your lordship wants me to address on that, I will come back and I will.
The representation precedes this prayer, my lord. That is the same road is maintained by the PWD by everything, and yes.
Even under the
yes,
State Highways Act
it is
also.
all the party respondents of the PWD department, which is looking after the PWD roads.
Why is it not a land matter then?
May I come back on this, my lord? Because the State Highways Act 1964, it's according to that act that the adjacent area of the state highways, these are also considered.
Hearing on this, because if I don't have determination, then in that case it is
well, in that case, my lord,
because group 1 is definitely having group 1 judge is definitely having determination. So why
no? Group 1 judge is having the determination in respect of the land matters, except, my lord, that 1972 Act. 1972 Act is given with Justice Sengupta. It's a different.
72 Act is what? Unauthorized
that is for unauthorized occupants.
So,
that is different. Now
so this is not unauthorized occupants.
No, this is 1964 State Highways Act. This is State Highways Act.
Exactly.
Now, State Highways Act
goes under land.
This, but this will may not go under land because earlier we used to do this on group 9 also. But kindly give me 1 day time, lordship. If I find lordship,
eviction of unauthorized occupant 62 West Bengal land, public land eviction of unauthorized 1962. But his prayer, which we get it from the petition as well as representation, he prays for that consideration of that. Not it is specifically.
Nayanjuli is an adjacent to the land road. That is the problem.
SDO,
is under the as I understood, I have dealt with matters. I have judgments.
If it is National Highway Authority, would
Malad, may I just make one submission, Malad? Am I audible?
Yes, yes, you are audible.
Yes, it's not only one submission. Number one is this would come under the state highways. So this would necessarily have to grow up under group one. But if my learned senior friend for the petitioner is submitting that the Noyanjuli land, which is the water body therein, that is the subject matter of the dispute, then that would necessarily have to go under group 5 for Panchayat. So in neither of the circumstances, Malad, group 9 comes into the picture. So it's not a residuary matter.
Your Lordship, tomorrow, if your Lordship is not satisfied, then I'll go back, Lordship.
But if your lordship is pleased to Malad adjourn it, could it be kept on Wednesday, Malad? Then I'll physically address your lordship on this.
Why are you having...
I'm in some I'm not in town, Malad. Due to some difficulty, I'm having to travel.
That earlier we used to...
Very well, let's have it
after
on Wednesday. I'm not passing any order in this.
Lordship, day after tomorrow.
Wednesday, not today. Not today, Wednesday did. First over কোনটা? কি ছিল মেসেজ? দেখি আচ্ছা দুপক্ষ আছে তাহলে কি করে হবে? সাইজ থাকতে হবে। উনি বললেন আজকে হবে না, তাহলে কালকে নোট করে নেবেন।
বুধবার দিন হবে, বুধবার।
না ওইটা না।
My lord, item number 4, my lord, probably that has been passed over, my lord.
You were not there. Unless the both sides come, I'll not take up.
Yes, my lord, I have communicated to the council who is support for the state. They are engaged in different courts and...
You were not there when the...
Yes, my lord. I tender unconditional apology for that, my lord.
Not a problem. Let us have it tomorrow then.
Yes, my lord. Can it be taken tomorrow?
Yes, passed over means passed over for the day.
Okay. Grateful, my lord.
Number 11.
Lordship, I'm for the petitioner. Lordship, I'm being led by Ms. Chandwala, Mrs. She is not well, Lordship. I'm praying for not this week, Lordship.
Not this week?
Not this week, Lordship.
In this matter, my lord, I am the necessary party, but without adding me, my lord, as respondent,
They are praying for time, so in any case, no orders will be passed. Item?
11, Lordship.
Not this week, yes.
May I file any additional parts? My lord, because my lord,
you take out an application.
Order, which has been passed in my...
You take out an application if you feel so. Because they have taken time, I cannot pass any order on that.
Yes.
Item 13.
My lord, I'm paying for day after tomorrow because in this matter happening Mukteshwar Maiti, he did not come today, my lord. Yes, my lord.
My lord, in this
Take
matter,
it after tomorrow, my lord, not today.
in this matter, I am for the state, my lord. We need some time, my lord, for the come with the report, my lord. Kindly.
Let it be taken up on Wednesday. You make the prayer because today she has only prayed for adjournment. It will appear on Wednesday.
If you pass an order given to report, I have no problem.
I don't know what the matter is. You have to move the matter.
The answer authority, forest range officer.
Let it appear on Wednesday. You make your prayer.
Number 14.
Today, I am appearing for the petitioner.
Yes.
The petitioner made an application for granting the educational loan. It has been sanctioned by the bank authority.
The writ has become infractious, lordship.
So it has now become infractious. So, my lord, it has been disposed of.
It has been submitted by both the parties. Your grievances have been redressed.
Yes. The loan has been sanctioned.
It has been submitted by the petitioner that the grievances of the petitioner have been redressed in as much as the request for loan has been acceded to by the bank and loan has been sanctioned. Full stop. The learned advocate appearing for the respondent bank submits that the writ petition has become infructuous. Full stop. Paragraph. In view of the submissions aforesaid, the writ application is disposed of as having become infructuous.
Well, affidavit of service may be kept.
Affidavit of service may be.
I'm deeply offended.
My lord, I beg of the petitioner.
করে একটু দেখে দেবেন সবার এটা। না, এটা করে দিই, চলে এসছে যখন। হ্যাঁ ঠিক আছে, এটা করে দিই তারপরে ওটা।
15 my lord, I am applying for the S1 number 2 KMDA.
My lord, this is the second round litigation. The petitioner before your lordship, the tenant since 1964 of a shop room lying and situated 73 Dhakuria Station Road, my lord, and running a business Noskor Hardware with valid trade license, and subsequently for the purpose of widening of the street, my lord, the KMDA authority has acquired the entire premises, my lord. But since then, my lord, no allocation letter, no any requisition notice has been served, my lord. And what happened, my lord? When petitioner was out of station on 20th March, my lord, and returned on 2nd April 2028, my lord, he came to know that on 29th March, the concerned authority demolished the entire premises, my lord. Then he made representation, and thereafter, my lord, concerned authority held several meetings for rehabilitation, but no rehabilitation has been made, my lord. Subsequently, he moved the writ petition, my lord, and on
page 63, my lord.
On page 63, my lord, Honorable Justice Sabyasachi Bhattacharya pleased to pass an order directing upon the concerned authority to conduct hearing and pass reason order, my lord. And upon hearing, my lord, the concerned authority passed the order, my lord.
Page 70.
Page 70, my lord. The reason order, my lord.
Annexure P16.
P16, page 70, my lord. I had the hardware business, my lord.
All right, kindly come to page 75, clause V. মানে short একদম, মানে effective portion, my lord. আচ্ছা, বলতে দিন।
My lord, I had the trade license for hardware business, my lord, with fire license, my lord. And this shop has been allotted to me in the first floor, my lord. But in the first floor, my lord, hardware business cannot be conducted, my lord. And the concerned fire authority has not allowed me to conduct this hearing, this business, my lord. And my lord, the area mentioned, there no area is mentioned, my lord. And in the ground floor, my lord, so many persons are granted the shop room, my lord, allotted the shop room, my lord, who had not the earlier the occupier of that area, my lord. New persons has been, no proper list has been provided, no any reason has been given to give me the shop room in the ground first floor, my lord. And the area has not been mentioned, my lord, anywhere.
But I see from the order dated 14th of December 2022 that you yourself said that you were allotted shop mentioned.
My lord,
that serial number.
subsequently I got information, my lord, RTI during pendency of that writ petition, my lord. Kindly come to that, my lord. The portion, my lord, which I got from RTI, my lord. Subsequently, I got, my lord, that page 62, my lord.
Page 62.
Page 62, my lord.
Yes.
It is not given to me. From others, my lord, I got this information and I got this shop room. And I accordingly, I challenged, my lord, before this writ petition, my lord, with a supplementary affidavit, that no reason has been given to provided me that shop room, my lord. In first floor.
Where you have challenged?
My lord, in that writ petition, my lord.
But
and also I have
but this
made
writ petition was disposed of ordering you to give that shop only.
Only not that shop, my lord. That shop, my
page
lord.
65, see page 65. Hence, WPA number such and such is disposed of by directing the respondent authorities to allot the particular designated shop room allotted in the name of Vishnu Noskor, subject to you proving your identity.
Sir, my lord, that shop room, my lord, some reasons would be given, my lord.
But how can I surpass the order passed in the earlier writ petition? I am bound by that.
My lord, I have given representation, my lord. Thereafter, my lord, and also appear in the hearing, my lord, to give a shop room in the ground floor, my lord.
But your fate was sealed with this writ petition only. This was passed on your representation.
Designated shop room, my lord, only particular designated, my lord.
The designated shop room means shop room number 22. That has been given at page 64.
And subsequently, I got this information, my lord. It is not provided also to me, my lord.
But the order was passed on this basis. You have taken advantage of this order then.
Yes, my lord.
And why are you not giving him a shop room of 170 square feet?
And it is not given whether it is 170 or not.
Well, can I come to page 75, my lord? Clause 5. We have already written. 5. May I read, my lord?
I've seen this. That he is not interested to shake any other shop in any other locality far away from this locality.
Not what can do, my lord.
Why are you not taking it at a different place? Why do you want it in that building only?
Some other interest, my lord, then calculated.
Hey, you take instructions. I'll come back in 5 minutes.
My lord, my lord.
My lord.
ষোলো
16 করে ডাকেনি,
আসবে তো 16 এখন
15 শেষ হয়নি।
15 শেষ হয়ে গেল না?
আমি একটু উঠেছিলাম।
হ্যাঁ।
বলে
এত থাকতে পারবো না। বলো না। হ্যাঁ, ঠিক আছে।
বাইরে গেছে। Yes, sir.
My lord.
Your client is not willing to take it at some other place.
My lord, he takes some other place, my lord. If it is available in the Dhakuria area or any Jadavpur area locality, within the locality,
Why don't you give him? Because he'll not be able to carry on his business. What is the use of giving a shop room if he doesn't fit in it? Because his problem will be solved also, and you will also be able to discharge your obligation.
No, my lord, we are already ready to give him the shop room, my lord. Kindly see here.
Anna, he is ready to get it in the same locality at a different place.
This is a very old case, my lord. If we have no place, other place, how can get?
No, but he says that he also stated that he is not interested to take any other shop to another locality far away from this locality.
Then, my lord, one thing, my lord, my humble summons before your lordship may file an application before the authority. After the hearing, after the process going on, if authority seeks to give them other locality, then he will get.
Can you take instruction as to whether the authorities can give him anywhere else if it can be shifted?
Can you pass an order on that effect? I will take instruction, my lord.
within the locality, any place, my lord.
Can you pass an order?
They say away from this locality.
It is far away, my lord. If within the locality, my lord, he is the aged person, my lord.
Because the read code, what you pass the order, I am complying with that as per the read court order, my lord, my lord. There is no new cause of action start, my lord. This is my humble submission. That is why I am submitting before your lordship. Can you file any application before the authority, my lord?
I am disposing it of granting you leave to file application. If the authorities consider it feasible, they'll give it to you.
My lord. My lord.
Because by the order, by the earlier order, you were also given liberty to file suits.
Suit, my lord.
Suit, my lord. Yes,
for
my lord.
claiming compensation.
My lord.
That you have done.
No, my lord, that has not been done.
You could have done
the
that
limitation
also.
is till now, my lord.
Limitation
That is
is there,
3 years
yes,
is
that I have
limitation,
seen.
my lord.
All right.
My lord.
Let them, my lord, if they file any report, my lord, regarding if there is any.
Not record, my lord. Not record, my lord. Already,
that purpose will serve, my lord. Again, I will file application.
Already reason order passed.
I
new
don't
cause of
find
action
any
start.
right. You had to pay money for getting this shop room.
No, no. It is only rehabilitation, my lord. And my other articles regarding the my money.
Why is it lesser in area? If it was 170 square feet.
But at this juncture, I have no idea, my lord. Can you pass the order? If the authority may consider, my lord. Any other
The writ petitioner has approached this court seeking a direction. Of approximately 70 square feet. Known as DEVOLOK, Develop Market 70/1, Clear Station Road, comma. The writ petitioner is the opponent.
A tenant, my lord. He was a tenant, not owner.
Opponent, not opponent.
Tenant.
Tenant, my lord.
For the tenant in respect of a shop. The petitioner had to going to into the building which housed the petitioner's tenant shop being demolished. Scheme of broadening of India Station Road. The petitioner was not given any application, and as such, he approached this court by filing WPA number 6308 of 20. They said WPA petition was disposed of by this court by an order dated December 14, 2020. To allot the particular designated shop room to allot the particular designated shop room, comma, allotted in the name of Vishnu Noskor, comma, subject to the petitioner proving his identity by sufficient documents to the satisfaction of the respondents. Inverted comma close. This follows from the said order that case of the petitioner before when the order dated December 4 to be passed that petitioner was allotted
A reason order was passed, my lord, thereafter.
No, that the petitioner's name, figured at serial number 22 in the list of allottees of shops at 70/1 Dhakuria Station Road.
My lord, his name is Vishnu Podo Noskor, my lord. There are only Vishnu Noskor.
That the allotment was made in favor of the petitioner as long back as on September 26, 2007. In terms of the order passed by this court on December 14, 2020, WPA 6308 of 2020, the respondents have allotted shop number
29 of the said building. Page 75, my lord. Before the last paragraph.
Which appears as the shop number
20
against item number 25. List of allottees was placed before the court on 14th of December 2020. The petitioner today aggrieved by the fact that aggrieved, stating that he said shop and that the said shop room is situated at the first floor of the building, which is not suitable
and feasible, my lord.
Carry on his business of hardware. The petitioner submits that the shop room that he had lost the tenanted shop room that he had lost, owing to the demolition, was one having area of 170 square feet, and it was at the ground floor. Petitioner submits that allotting a shop room at the first floor of the building would not serve his purpose, and discuss the petitioner refused the order dated August 29, 2024, by which the petitioner's request allot another shop room at the ground floor of the said building, i.e. Devlok Market. Another shop room measuring 170 square. Another shop room measuring at the ground floor of the said building. Has been turned down. The advocate appearing for the respondent, you are appearing for?
Respondent number 2, KMDA.
Of the other respondent?
State.
State ho jata kuch.
This one number 1. You are only appearing for 2.
2, 3, 4, all the KMDA
But
responded.
they are the principal dependent one.
Answering responded.
They are the answering respondent one.
5, 6, 7, who is appearing?
7 is the website.
My lord, 2, 3, and 4. I am appearing.
You have served all.
My lord, I have served all. I have served all, my lord.
You are satisfied.
My lord.
2, 3, 4, my lord. I am appearing for 2, 3, 4.
Respondent numbers 2, 3, and 4.
KMDA.
I.e. the KMDA authorities.
One.
Submits that shop room number 29 has been allotted to the petitioner in terms of the direction passed by the court December 14, 2022, WPA 6308 of 2010.
My lord.
He further submits that upon the direction contained in the order dated December 14, 2022 being complied with,
My lord.
no cause of action survives for the writ petitioner,
My lord.
and as such, this writ petition should not be entertained. The learned advocate appearing for the KMD authorities further submits that it is not possible for the KMD authorities to provide any other shop room measuring 170 square feet said market, as there is no such space vacant in the said market, which has already been indicated in the order dated 29th August 2024, which has been impugned in the writ petition.
My lord.
Having heard the learned advocates appearing for the parties, for the respective parties, and Having perused the material on record, feels that the order dated 14th December 14, 2022 was passed on the basis of the petitioner's representation that the petitioner was entitled to the shop room designated for the petitioner in terms of the list of allottees of shops at 70/1 Dhakuria station. The list of allottees of shops at 70/1 Dhakuria Station Road, which has been annexed at page 62 of the petition, shows that petitioner's name figured at serial number 22 and the designated shop room means the petitioner's name was
29.
Shop number 29. Today, during the course of hearing, the petitioner sought to insinuate that the name of the allottee appearing at serial number 22 was Shri Vishnu Noshkar, while the name of the petitioner is Shri Vishnu Pada Noshkar. That submission of the petitioner cannot be countenanced at this stage because the same submission was made on 14th December 2022 by the respondent when WPA number 6308 of 2010 was being heard of by this court. Such fact would be apparent from paragraph 3 of the order at page 2 thereof. Paragraph 3 now, third paragraph at page 2 of the said order. Full stop. In any case, having exercised his option of getting the designated shop room in terms of the list of allottees, the petitioner cannot today be heard to take a contrarian stand. This court is unable to accede to the request made by the petitioner to a writ of mandamus as prayed for. The writ petition is therefore not entertained. It will, however, be open to the petitioner to make an application to the respondent KMDA authorities for allotment of a different shop room of adequate size at the ground floor of the same premises or some other premises, or to shift the petitioner from the said Shop room number 29. To a different shop room of adequate size at the ground floor of developed market, if it is so feasible for the KMDA authorities. KMDA authorities would be free to take decision as regards such reallotment on the basis of infrastructural availability. Full stop. That's it. Suppose authority WPA such and such and Cisco's law.
I'm good. What is it mean?
But I am appearing for the petitioner. But here is the grievance of the petitioner that the petitioner made an application for educational loan. My lord, that has been rejected on the basis of that they scored low. But in this lordship kindly see page 33. That is the order passed by the bank authority. That is rejected with reference to the above. We hereby advise that according to the risk scoring model, the score is 42-47 for the application. Hence, lending decision is declined. The scoring model sheet is attached for your necessary action and perusal. Lordship kindly see page 36. That is the judgment passed by this court by my Lord Justice Manta. On the same ground, my lord, that is rejected by that time in similar circumstances. Lordship kindly see the page 36. My lord, the line is that the paragraph 3, the bank has refused the application of the petitioner on the ground that the loan application was out of the service area and lower scoring for processing. This court has not been able to appreciate the exact reason for refusal except the residence of the writ petitioner was outside the jurisdiction of the respondent number 8. My lord, then next page, my lord, that is in view of the Kerala High Court judgment, my lord, that order is passed by the my Lord Justice Manta, setting aside the order of refusal and the directed to reconsider the application which has been submitted by the applicant.
In the light of the future.
So, Lordship, I am praying that before Lordships that I have annexed the judgment. So, kindly see the judgment and pass the order in the same terms, my lord.
My lord, kindly appreciate. My lord, kindly turns to page 15, where this circular is annexed, my lord. It is a loan under the Vidya Lakshmi portal, my lord. My lord, the circular starts from page 14 onwards. My lord, I'm pointing out at page 15, my lord. What is the objective of the scheme, my lord? The educational, my lord has got paragraph 2, my lord. The educational loan scheme outlined below aims at providing financial support from the banking system to meritorious students. So that is one of the criteria, my lord. It should be provided to meritorious students. And my lord, we have a decision of this honorable of the honorable division bench of our honorable High Court, my lord. My learned friend also appeared in that matter. I do not know whether it is reported or not, sir. My lord, kindly sees a similar point came up. The application was rejected because the petitioner or the appellant herein has scored a low marks, or his marks was below 50. 50 is the benchmark, my lord. That is a policy decision of the bank. There should be some benchmark. So, my lord, here also can you cease?
Marks in her academics, risk scoring.
And our division, honorable division bench was pleased to deal with this decision passed in the Kerala High Court also.
That's the division bench judgment is for the academic qualification marks, not the lowest scoring.
Risk scoring.
Not
My lord, may I point out page?
So that,
page
my lord,
internal page
kindly
3.
say the eligibility criteria.
Third paragraph of the internal page 3, my lord. Undisputedly, in this case, the appellant had secured only 49% marks in the qualifying examination. Therefore, the loan application has been returned by rejecting the case by communication dated 7th November 2020 and clearly records the reasons for rejection. It mentions the appellant's RSM means retail score model. Score achieved in LOS means loan originating software is less than 50. So whatever marks they have obtained, there is a software in which it is, my lord, these data are entered.
What is the percentage of marks in the qualifying examination here?
50, my lord. That is the benchmark.
In this case?
In this case, 50. Everywhere it is 50.
What has she obtained?
See, my lord,
whatever.
The rejection, he says, page 33, my lord.
33.
Yes, 33.
34.
33 rejection.
No, this is about something else.
My lord, can you see 42 to 47?
What is the
That is not the academic. Page 34, my lord.
Here also, my lord, that was not only academic, my lord. Here is RSM. My lord, RSM, it stands for retail score model. My lord, here see, my lord, can you scoring model? With reference to the above, we hereby advise that according to risk scoring model, RSM. Here also RSM. In the division bench order also, my lord, can you see? It is RSM. RSM was below 50. And RSM model, the score is 42 to 47 for the application. And how we have arrived at, we have also calculated
what is the percentage of marks scored by her in the qualifying examination? Is there anything to show here?
No, my lord.
No, not in the record, my lord.
No, we not only the qualifying examinations, all the examinations, my lord, can you see the next page, page 34. The reputation of all these factors are taken into account, my lord, before calculating.
From the judgment of the division bench that you have placed, it appears
that is qualifying marks.
Please.
My lord.
In this case, the appellant had secured only 49% marks in the qualifying examination.
My lord.
Right.
Now, what is the percentage of marks obtained by her in the qualifying examination in this case? Because I find past academic record.
Yes, my lord.
As one of the criteria.
But out of which she has secured 5, my lord.
She has secured 5 points, which is less than or equal to 60.
Yes, my lord. And ultimately, my lord, perhaps, my lord, this is not very much clear from the order of the honorable division bench, my lord. It says, my lord, at the end, my lord, can you see the last line of the third paragraph? It mentions that the appellant's RSM means, my lord, risk scoring model. That is a factor, my lord. Risk scoring model means after calculating all the criteria, my lord, we have arrived at. So it is a recent order, my lord.
Yes.
The order is a recent order, my lord. And this reasoning has not been challenged, my lord.
Yes, Mr. Basu,
My lord, may I submit?
take this one, take the division bench judgment.
My lord,
Your mentioned
yes,
cited. It also speaks about the loan originating software. You take second page, page 2 of the order. Page 2 of the division bench order, last paragraph,
Loan originating software.
the submission
50%.
which has been made.
my lord. Cut-off marks of 50%, and since they
So
have
this
given-
cutoff marks of 50% was for the loan originating software. The loan originating software prescribes a cutoff mark of 50%. So going by that at page 34, the percentage of marks obtained by the candidate here is 42.47.
But in this aspect, may I submit one thing? But I have come before your lordships. Regarding the application has been rejected on the basis of the low scored mark, low scoring model. Then I am praying before your lordship to reconsider the prayer of the petitioner. I have seen in many cases when this court passed the order to reconsider, bank has reconsidered this. Because of that, on the basis of that, this scheme has been for the students only. Because
but
no
in the case,
student
in the
should
case
be-
where order of reconsideration was passed, this division bench judgment was not placed. Once this is placed, how can I ignore this?
division bench
This
passed
division
the
bench
order
has-
on the basis of the
This
qualifying marks.
No.
No.
Kindly read paragraph 3 at page 2 must be read. I mean the qualifying marks must be read in the light of this.
For the order.
Why should not council?
Kindly see the last line at page 3. Last line, paragraph 3 at page 3. It mentions that the appellant's RSM score achieved in LOS.
Less than 50. The place
Your score in LOS here is 42.47.
division bench judgment a place for any provision. We consider order the division bench order.
Mr. Saha, what is your bank doing in Kerala? In Kerala, I found that there is a judgment there. The judgment that
Kerala
has been
judgment
referred.
is division bench judgment. That is, nobody should be deprived of getting the loan. Because of that, education is the main system.
My lord, this Kerala judgment was also
Nobody
considered
should
by the
not
division
be-
bench, honorable division bench. My lord, can you see page 2, second paragraph?
No, I wanted to know the
Outcome. my lord.
the steps with the which bank is taking in Kerala. Whether bank is taking different steps here and there. That is what I wanted to know.
That I have to obtain instructions. My lord.
But if that is so, tomorrow I shall show the judgment of Kerala.
Okay, I'll be bound by the division bench of Calcutta. Kerala will not bind me.
No.
Kerala will not bind me.
Ultimately,
Kerala judgment has been considered by the division bench. The problem here is that I would have understood if it was only qualifying marks, which you pointed out. But the division bench also takes into consideration the RSM score.
Lordship kindly pays 31. Before that, after the division bench judgment, this court passed the order for consideration on the
and
same ground.
loan was granted.
Loan was granted. That is the order I have annexed.
Division bench may not this division bench judgment has not been placed.
Page 31, my lord.
Not placed.
This was only for because the representation had not been considered, but here it has been considered. Reasoned order has been passed.
The same ground I am
No,
saying,
it is not same ground. Kindly see page
but
31.
that time the bank has not been placed that order.
That is different. See, because bank had not considered it. Please see page 31, paragraph 3.
Similar matter, item number 14.
Take instructions whether application has been disposed, considered or not. Bank had not taken a decision there. In that background, the order was passed.
Item number 14.
But before that, I have done the matter, item number 14. Your Lordship, since that the bank has considered the clear. This is the
Bank is taking different stand in different cases.
Same thing as the
LOS may have been more there.
Bank is
I don't
taking
know the
different
facts.
stand in different cases.
The LOS may have been
bank
more there.
is
It may have been more than.
continuously taking different stand in different cases.
You should point that out in
Or
the petition. That is not there. You have not pointed out any different stand as yet.
After filing the writ petition.
This was after filing the writ petition.
In one
Whatever,
case.
I have to see the
One can
contradictory
consider
stand
one
to
case.
conclude on it.
But then I can, my Lordship give me liberty to file supplementary.
Same
File
case.
supplementary.
Same case bank has allowed.
Same case bank has considered, or in this case not considered.
Very well. The writ petitioner, kindly take it down. You have to make some submissions. Very. The writ petitioner is aggrieved by
I'm there for the response in 21.
21, not this week.
Same prayer for the Lordship, item number 20, only day after tomorrow, Your Lordship kindly.
Item 20.
20, day after tomorrow.
Day after tomorrow means Wednesday.
It may be
Make the prayer when the matter is called on, because
actually this matter may be tagged with the
very well, let it be called on.
tomorrow I have some difficulty. That's why tomorrow I have some
Ask somebody to pray for time.
Okay, Lordship.
ওনাকে জিজ্ঞেস করুন
তাহলে দাদা দুটো ফাইল
এই 21টা কি নর্থ দিস উইক করলেন
ফার্স্ট নম্বর করে দেখে যান। আচ্ছা হ্যাঁ, কিন্তু দেখে যান একবার। হ্যাঁ হ্যাঁ। এক একটা করে ডাকুন, এক একটা করে ডাকুন, আছে কেউ কেউ আছে।
Lordship, this is the affidavit of survey. I beg to appear for the petition.
Yes.
Affidavit of survey. Lordship, the grievance. Lordship, the grievance and the prayer of the petitioner is very innocuous in nature, Your Lordship. The petitioner was the holder of a passport since 24th August 2010, and the same had expired on 23rd August 2020, Your Lordship. Thereafter, he had applied for a reissue of the passport on 6th June 2022, and finally, and an amount was also paid in that regard for the application process on 4th June. Your Lordship, thereafter, the respondents had sent a letter. It was for a show cause that some adverse police report has been received by the respondents. That's why the petitioner was asked to show cause. But unfortunately, the petitioner could not file the show cause. The primary reason was that he was unaware about which cases are pending against him. Thereafter, on the part of the petitioner, he had gone to the police station. He had asked for any report from there, but he was not given any form of report, and that is why he could not file the show cause. Right now, the prayer of the petitioner is that the report be provided to him so that he can file the show cause. There has been a delay on the part of the petitioner, that which I also admit, of around 2 years, Your Lordship. This is the situation, but the prayer is only this.
You have for respondent numbers?
Lordship, I appear for respondent number 1, 3, 4, and 5.
1, 3, 4, and 5.
3, 4, and 5.
The other respondents have been served.
Your Lordship, everyone has been served.
Please show me the affidavits of service. Oh, thank you. So your grievance is against the passport authority?
Your Lordship.
They are represented. You are the passport.
I'm representing.
Why don't you give him the police verification report? Because it will be easier for him to respond to your show cause.
Only in this case, only problem is that the report, my lord, my lord, exempted under the section 224A of the Act, my lord. Here, Act, my lord. My lord, I am relying on clause 1B. That is the all police report except under the order of the
But this is under Right to Information Act. He has not sought for it under the Right to Information Act, has he?
No.
Your Lordship, no.
You have sought to not renew his passport or not grant him passport on the reason of there being a police verification report against him.
Adverse police.
If there is an adverse report
Show cause,
against
my lord,
him,
only show the year was issued. The show cause notice was issued, my lord. Only asking them to explain why there was suppression, my lord.
That also we are not aware, your lordship, which case is pending and all. Suppression is when, your lordship, I am aware of that fact, that these cases are pending.
Because my lord said you are therefore upon to provide a suitable explanation within 30 days. Please note that you are required to furnish a proper explanation regarding the circumstances under which you have suppressed the information, my lord.
You are not aware about
That is my instruction, your lordship. Which cases are pending? What is the report exactly? Nothing I am aware of. If that be provided, your lordship, immediately I can file a show cause. Yes, these are the cases which are pending against me. And that also affects my right, the basic principle of natural justice as well, your lordship. Because if I don't get that proper document, your lordship, it's not possible for me to submit that show cause. If yes, there are cases pending against me, fair enough. I will submit in the form of a show cause, your lordship.
Where have you mentioned in your writ petition that you were not aware about the police cases pending against you?
No mentioning, my lord.
I am appealing for the state malady in this matter.
Yes, sir.
Central government or
Lordship, the state government is represented from there only. This can be cleared with what is the verification, what is the key, because from the police only the verification report has been submitted. If that is given, your lordship, immediately a show cause reply can be given.
Why have you not mentioned in the writ petition that you were not aware about the police verification report? That is not there in the writ petition.
Yes, my lord.
Lordship, I had to.
You submitted just now is not there in your.
Aspect was not adhered to. This your lordship, I came to know right now because that on this ground it was regarding suppression of fact.
That is the notice. The notice itself says it is for suppression. If you see
Your
page 7.
Yeah, your lordship. That is the notice.
Regarding the circumstances under which you had suppressed the material information in a passport application.
Lordship, it was not mentioned also. I admit that quietly, your lordship. It has not been mentioned. It has not been pleaded in the pleadings, your lordship.
Madam, what is your submission?
I just now, till today I did not get any instruction, madam. I will, madam, see page number 17, madam. Page number 17.
Yes, I am on 17.
Yes, madam. That thereafter I will not get any instruction, madam, and I will take instruction, madam.
When can you come back?
Madam.
When can you come back, ma'am, with instructions? Next week.
Manda, my lord.
So what? Telephonically, by email, you can get the instructions.
Or your lordship, just if I get that information immediately, the show cause the prayer is very innocuous in nature, your lordship. I'm not telling this fact.
Come back on Thursday. Learned advocate appearing for the affidavit of service filed today, be kept with the record. The learned advocate appearing for the writ petitioner submits that the writ petitioner is aggrieved by non-supply of the police verification report, adverse police verification report to him although the same forms the basis of issuing to him by the regional passport authorities. Learned advocate appearing for the respondent numbers 2, 3, and 4. No, 3, 4, and 5. Submits that police verification report cannot be supplied to the writ petitioner in as much as the same is exempted under section 24, bracket 4 of the Right to Information Act 2005, and for such purpose he relies on notification dated August 29, 2006, issued by the Government of West Bengal.
Full, my lord.
B for the has been third. Next Thursday is next.
Grateful, my lord.
Twenty, 21.
Lordship, in 20, I am appearing on behalf of the respondent numbers 7, 8, and 9. In item number 20, Lordship, I am appearing on behalf of respondent numbers 7, 8, and 9.
The petitioner is not there.
I think, Lordship, I am not standing in the way. I am grateful.
21.
My lord, in item number 21, I'm praying for not this statement. Grateful.
22. 23. 24. 25. 25, my lord, I beg to appear on behalf of the respondent number 4 and 5, WBSCDCL.
Item 20. My lord, Senior Advocate Mr. Parthasarathi Bhattacharya is appearing on behalf of the petitioner, my lord. My lord, I am instructed by him. Kindly, my lord, adjournment today. Just kind, only one day, my lord. Tomorrow he will do the matter.
Not today. I am making not today.
Grateful.
26.
Lordship, I'm late by my senior, Mr. Arnav Das. He's not available today. Your Lordship, I'm praying for not today. Obliged.
27.
Stand for the petition, Lordship. Lordship, here in this matter, Lordship, there is
Conduct is not that far because there is a reason.
Lordship.
28. 29.
29, Lordship, I beg to appear on behalf of the respondent West Bengal Information Commission. The petitioner is
not there. Well, instead of tomorrow, if your lordship kindly take it up day after tomorrow. Tomorrow I have some personal difficulties.
Ask somebody to be there because
My
the
junior will
petitioner
be
is
there.
not there.
Sure. Grateful.
30, 31. 31, my lord, I am for the petitioner. My lord. Very short point. There is,
Your other side should be there. Because there is a resolution, so
then only not today. 32,
My application.
33. Right, sir, then I'll take up. Otherwise,
March.
One. 4, 35.
My lord, item number 23, my lord. In this petition, my lord, I am for the petitioner, my lord. Just, my lord, kindly consider, my lord, I am traveling to Madras, my lord. Just in the next monthly list, my lord, kindly fix. So after 5th April, my lord.
I cannot fix it. If you pray for an adjournment when the other side is there, because somebody was there, I think, when the matter was called out. It will be called on again tomorrow. Pray for an adjournment.
35 to 57.
My lordship, I am for the petitioner in item number 38. Yes, lordship. Your lordship, may I file my affidavit of service?
Till such time the other side comes, keep it with you. Tomorrow again it will be called out.
Okay,
My
lordship.
lord, this list will again be called down tomorrow also. My lord, I am appearing in item number 38.
I've been led by Mr. Shami Nandi.
You are for the petitioner or the
I am for the petitioner. She is my junior, my lord. We are both for the petitioners.
if both sides are there, I will take it. If one side is there,
No, my lord, I am for the petitioner. My lord, she is also for the petitioner.
side is not there. That's what I'm saying.
Yes, my lord. Tomorrow then. Tomorrow.
Both sides
Great.
should.
I get that.
Item 56, I am for the petitioner. I have informed the other side, my lord, to appear before your lordship because, my lord, some of the matters, my lord, is appearing before your lordship from courtroom number 50. So, my lord, I have already informed. If your lordship, my lord, want to give me, my lord, liberty to, my lord, move my case, then
But the other side is not there.
yes, though I have informed him.
Actually, there is a resolution because of farewell.
Yes, my lord, but it is, my lord, since 2018. My client
Tomorrow
is
again it will
somebody.
be called on. It will be called on
My lord,
tomorrow.
my lord, my lord. Grateful, lordship.
58 to 80.
But I appear on behalf of CAC on the matter. Item number 76.
Let us see when the other side comes.
I am for the petitioner for item number 74.
74. Other side is not there.
Everybody is citing.
Yes, yes, that is the problem. But I'll call the list. If I'll take a chance, if both sides are there, we'll have some matters disposed of.
It will be taken up from tomorrow, my lord.
Yes, again, same list will follow. Same list, same pattern. Excepting those in which orders have been passed or which have been put at the top.
81 to 102. $103 to 125.
122, my lord, I am for the petitioner. In this case also, my lord, I am informed my other side.
Achha.
My lord, if many, my lord, priority, my lord, can be given, my lord, upgradation. So, my lord, I am praying that 56 and 122, these two matters, my lord.
56, 122 opore kore din because they have responded.
My lord.
On behalf of the petitioner.
56 and 122.
Please inform your other side.
My lord, I am 122, 122 আর 56.
My lord, item number 60, I am for the respondent. I'm very sorry I missed the call, my lord.
Not a problem. It will be called again. It will be called again. It's not a problem.
My lord,
Grateful, my lord.
My lord, over telephone, I am informing them.
Okay.
My lord, grateful.
I'll take up only if both sides are there.
My
Because
lord,
this is a
I will
broken
inform that these are the upgraded by your lordships, my lord, over telephone. I am informing
It
them.
should be within the first 25-30 matters.
My lord, grateful.
Aye. Oh, there is a problem, ma'am, in getting it upgraded. Let it be as it is. Again, the list will be called tomorrow because there is a problem of some software
My lord.
in getting it listed. Let it be as it is.
My So, my lord, I am not informing anything.
No.
Grateful, my lord.
126 to 148. One 149 to 170.